not do nothing. So you trying to be funny, but whatever. You can kiss my ass.
I'm really not. I just want to make sure you come to court, but you're all set today.
I'm tired.
Okay. Calling 25 RB 00194, People versus Brianna Porter.
Your Honor, Randall Kane appearing as arraignment attorney on behalf of Brianna Porter. Porter, state your name for the court.
B-R-E. You said spell it?
No, just say it.
Brianna.
Your Honor, for court's information, she did advise me she did not want a court-appointed attorney. She was advised of her rights, and she walked out of the room and wouldn't speak to me any further.
All right, Ms. Porter, did you talk to Mr. Kane today?
Yeah, I talked to him. I'm just tired. Like, I really didn't even do nothing.
But let me just ask you some questions, and we'll just procedurally talk, because I don't want you to make any statements about the case on the record right now, okay?
I mean, it's the truth, though. I didn't do anything.
Okay, but the truth can be outside of a public courtroom. And this is just not the time and place for it. But I'm going to ask you some questions that I just need you to answer for me. And I understand you're tired. Everyone in this courtroom, I'm sure, is very tired today. So we're all in this together. Did you talk to Mr. Kane today?
Yeah, I talked to him.
All right. Did he go over your rights with you?
Yeah, I heard what he said.
Did you understand all of those rights?
I heard what he said.
Well, I understand that you heard it, but did you understand it?
Yeah, I can understand English.
Do you have any questions regarding your rights in this court hearing?
No.
I'm going to enter a not guilty plea for purposes of arraignment with regard to bond, Mr. Kane.
Your Honor, I have no information on Ms. Porter. As I stated, she walked out of the room.
Okay. Ms. Porter, where do you live and who do you live with?
I live by myself. I have my own place in Washington, Michigan.
Okay. And we have an address for, is that not a correct address?
That's my old address. That's my old address. I don't stay there no more.
Okay, so one of the questions Mr. Kane would have asked you if you had stayed in the meeting with him would have been an updated address to make sure that you can receive court notices.
Well, I can still give him an address. I just don't want. I don't want to talk to no judge right now. I mean, no, not like that.
I am judge talking to me.
I meant to say lawyer. I didn't want to talk to him at the time. I was really tired. I'm cramping on my period. Like, it's a lot going on for me. Like,
unfortunately, there are days we have to deal with things that we don't want to, and they're not the best days for us. I go those days myself. But Miss Porter, right now, I can't have you place your address on the record because I have a public courtroom full of people, and we are also broadcasting live to YouTube. So I don't place people's personal information live like that. So that is why we have you have those private conversations. And I will have Mr. Kane pull back into the jail to get an updated address for you because we need that address to make sure you're receiving notice to be able to come to court. Do you work?
Okay, what am I coming to court for?
For a disorderly conduct charge. Do you work? Are you employed?
Disorderly conduct for what?
Ma'am, I don't know the facts of the case. I'm just here to facilitate to make sure that rights are protected. People have a place to handle their.
So what is my verdict? What is my verdict?
There's no verdict because we're only here for an arraignment to let you know what the charges are so that you can prepare any possible defense to those. Ma'am,
okay,
do
so
you
when
work?
I gotta come back to court?
Well, do you work? Let's answer my questions first.
No, I don't. I do not work. I don't work. I don't work. I don't have no job.
All right. Based on my conversations with the defendant, one thing the court has to assess during assessing bond is the likelihood that the defendant will appear in court to handle the matter before the court. This is a disorderly person charge, which is a 90-day felony or misdemeanor, and the court is aware of that fact. However, based on my conversations with the defendant, I'm going to assess a $500 cash bond at this time. We are going to assess a pretrial. That pretrial will be January 16th. 2025 at 8:30 a.m. on Zoom. I do not have a judge on this file yet for my purposes. But if you are still
so you gave me until January the 16th for a disorderly charge, and you just made my bond from $260 to $500.
Well, like, number one, I never set a $260 bond, ma'am. I'm setting the original bond, and I'm setting a $500 cash bond. I never set any other bond, so I didn't change a bond because the bond consistent. However, was stupid. So I'm when not I go giving to court you any again, time. January 16th from now until then is 1 week. That is 7 days. That is the next court date I have for the Roseville docket, which is why I said it so quickly in the event that you are unable to bond out. January 16th is not a 7-day sentence because there is no crime to sentence you on at this time. That is just your next court date for a pretrial to assess how you want to handle this matter. I'm setting a $500 cash bond because I feel that's appropriate in this court to ensure that you will appear in court. You are welcome to post $500 in cash.
I don't care. I don't care. Like, I gotta sit here, whatever. I will sit my ass here and go to fucking sleep. This shit don't bother me. For real, but that was whack that you sat here and tried to give me that charge. You tried to give me that much of a bond for a fucking misconduct, and I did not do nothing. So you trying to be funny, but whatever. You can kiss my ass.
I'm really not. I just want to make sure you come to court, but you're all set today. Whatever, I'll come to court when Mr. Fox, are you ready on Booker?